In this video, we would like to discuss about permanent marriage, and permanent marriage is also called as Nikha. So, exactly in Nikah, the bridegroom gives a proposal to the bride, and that very proposal is called ijab. And when the proposal is accepted by the bride, then it is called kubul or acceptance of the proposal. And the very requirements of a permanent marriage or nikah, there must be presence of two witnesses. And regarding presence of witnesses, the presence of two witnesses as per the requirement of Sunni laws and Shia laws does not require any witnesses. But there is another requirement, that is the presence of guardians. And besides presence of guardians, there is the presence of relations, also presence of vakils, and the presence of kaji. So also there is the requirement of reciting of Quranic verses, and there is another important thing, that is price in consideration of marriage. Price in consideration of marriage. So finally there would be a Nikhanama, and that Nikhanama is otherwise called the marriage deed. So these are the requirements of a valid nikah or marriage under Muslim law. So besides that, there are certain other requirements to be fulfilled in a valid nikah, and these are regarding the capacity or regarding the form or as regarding to the consent. So when you will go to the very form that is required in a valid nikah, one is, as already we have discussed, regarding proposal and acceptance, that is of ijab, that is given by the bridegroom as proposal to the bride, and when the bride accepted it, it is otherwise called kubul. And the second one is present of witnesses, and as under Sunni law, there must be presence of two witnesses, but under Shia law, there was no requirement of any presence of witnesses. Then the price in consideration of marriage, the presence of the vakils, and the nikah is performed by the kaji or mullah, and that also by reciting of certain Quranic verses, and finally the Nikhanama or marriage deed. And all these are requiring to perform a valid nikah. And regarding the capacity of nikah, the very requirements are soundness of mind, and that is attaining of poverty. Poverty, that is, one is soundness of mind, and the second one is attaining of purity, and that is regarding, as per the Hidayah, the traditional source of Islamic law, the male must be at the age of 12, and the female at 9. But the presumption of this is around 15 years. And the Indian Majority Act of 1875 is not applicable to Muslims. Neither also the Child Marriage Restraint Act 1929 or the Sarad Act, of which Section 5 punish those who are responsible for a marriage of minors. But here under Nikah, the parties to marriage left unpunished. And as regarding to free consent, and it falls under, one is free and voluntary consent, and the second one, the consent of the guardians. So also the consent must to be communicated through the guardians. So these are in relating to consent. And besides consent, another requirement is the various impediments or prohibitions which are provided under Mohammedan law or Muslim law in relation to a nikah. And besides that, one thing we've derived from that every nikah is a contractual idea or concept, and this contractual concept of marriage that we derived from nikah. And as the consent of parties, if they are majors, and consent of the guardians if the parties are minors, so it is supported by the majority sects under Muslim law or Mohammedan law, like the Hanifs, the Safis, the Maliks, even the Shias. So to all, marriage must be communicated through wali or the guardians. Then the next one is regarding registration of nikah or marriage under Muslim law. So in that connection, registration is not compulsory, but it is a voluntary registration. And as per the voluntary registration, certain acts were enacted, and those are in respect to Bengal and Bihar in 1876 regarding voluntary registration of nikah or a Muslim marriage. And in case of Assam, it was enacted in 1935, and in case of Odisha, it was enacted in 1947 regarding voluntary registration of an marriage under Islamic law. And besides that, another aspect of nikah that we could derive by presumption of lawful marriage, and what we can derive by presumption of a nikah or a lawful marriage, and that evidence of Nikhanama, that is one presumption, and calling witnesses, that is another presumption, and the very statement of the kaji or mullah who performed the nikah. So also in case of absence of all these direct evidence of marriage, we can infer the very nikah or the lawful marriage from the following circumstances. And those following circumstances could be discussed under these four grounds. One is prolonged, continual cohabitation between the husband and wife, and the second one, recognition of such relation or cohabitation between the husband and wife by the relations or friends or neighbors. And the third one, that is acknowledgement of such nikah or lawful marriage by the husband himself. And the fourth one, acknowledgement by the husband of the children resulting from his union with the woman. So, these are the very results of presumption that we could derive whether the very marriage or nikah was lawful or not. So, our next would be the very question of the very distinction between nikah and muta. And this very distinction between nikah, which is a permanent marriage under Islamic law, and muta marriage, that is a term marriage, is also under Islamic law, and that distinction we would discuss in our upcoming video.